Great. So please feel free to introduce yourselves.
I'm Nicole Kaloran. I'm the director of the Vermont Small Business Law Center and Clinic here at Vermont Law and Graduate School. We help businesses access legal services and education. Thomas?
Hello, everybody. My name is Thomas Durham. I'm a 3L or third year law student and also working on my master's in arts and restorative justice. And just wanted to say once again, thank you everyone for being here and thank you for allowing us to hold space. It's an honor to try to be here to help bring a little information into your lives that might be helpful.
Thank you both for being here. So let's kick it off with, can we just get some terms defined? Like, what does any of this actually mean?
We're going to skip the agenda and we'll go straight to the terms.
Great.
Nobody needs an agenda, right? Yeah. So these are some of the common terms that you're going to see in the contract section. I did not put one together for torts because we sort of defined some of the torts, some of the terms in that section, but there's a lot of terms that go into contract language that lawyers use that might be a little unfamiliar. So there's some of them. Bargain, we're not talking about a sweet deal you get at a store somewhere. This is a back and forth and exchange, also called quid pro quo. Boilerplate is what we call a standard form that folks use as a contract or terms and conditions, usually can be negotiated, although most folks don't like to negotiate boilerplate language. A waiver we'll talk about as one tool that businesses can use to be able to minimize or mitigate risk. It's basically a document that folks sign that says that I am responsible if I get injured. The other ones here, you can see NDA, non-disclosure for confidentiality when that's necessary. Damages and remedies is what we call what people ask for when a contract is broken. Damages, how are they hurt, and what's the monetary amount that's assigned to that. Security and collateral is a term that you'll use when it comes to secured transactions, things like a mortgage or a home loan or a lease that's secured by a piece of equipment or something like that. The security or the collateral is the valuable thing that's put forward as a promise if the debt goes bad. A guarantee is something that's particularly applicable to small business owners, especially sole proprietors. If they have a business entity and they sign personally for a debt of the business, then they might be personally responsible for paying that debt if it goes bad. And you can see the others, repossession mortgage. That's the process that is to retake collateral or retake security items. So that the mortgage is ended by a foreclosure, for example. That's a process where the home gets taken. A lien is a piece of paper that basically attaches to property to make sure that there's payment that's going to come for the debt when that property is sold. So that's just some of the terms. Do you need any more on some of those?
Well, so one, I forgot to say, we'll send around the presentation after the fact. So you all can write this down and also you'll have a copy of the presentation. But Nicole, why is it important for these contract terms to, like, why do we need to know these contract terms when we're talking about torts and liabilities?
Because there's a lot of terms that are used when it comes to talking about torts, liability, lawsuits, contracts, things like that. And so these are actually convenient for us. This is shorthand. So when I say security or collateral, instead of saying it's a valuable item that lenders can take if you don't pay, lawyers use that a lot. They use shorthand to say this is one big concept squished into a couple of words. So,
okay, great.
All right. Sorry, here we go. Contracts 101. What the heck is a contract? And pause me if you want to ask any more specific questions or if you want me to stop on any of these too. Overall, this is something that we study quite a bit in law school, believe it or not. This first statement, enforceable statement of a bargain, reasonably detailed in writing or signed, specifically one that is negotiated. So both sides of a contract are giving up something. That is what most of the first year of law school contracts talks about. And it's something that really never comes up in lawsuits when it comes to enforcing contracts. But there's some important words there. So it's an enforceable document, something that can be enforced against the person who breaks it. It's a statement that's reasonably detailed so that folks who look at it can see what the agreement was and what everybody agreed to when they signed it. In writing and signed can be important for a contract. If it's in writing and signed, it can be enforceable. There are some debts that cannot be collected if there's no writing, if there's no signature on a piece of paper. And those are things like purchase of land, sale of goods for more than $500, or an agreement that takes more than a year to complete. So those three items are specifically have to be signed. There is a very broad allowance to contract in the United States. Basically, unless something is against public policy, if it's specifically against a policy that the federal state government has set, it will probably be enforceable in a contract. That's the most common question that we get is, can I really put this in a contract? Can I do that? What if, can I actually enforce it? So the answer is usually yes, you can put that in a contract. It might be a different matter to enforce it, but you can definitely put it into a contract. There's 4 basic parts to a contract that you can see here. There's the core deal. This is what the business owner is good at. They know what the widgets are. They know how many are being sold, what the color is, what the amount is, when it's going to be delivered, all that. The rest of it is the stuff that lawyers are really good at. What promises need to be made to make sure this transaction is secured? What procedures need to be followed in the event of providing notice to someone, if there's a default, if there's something that goes wrong, if there's an injury or disaster, what are the protections that are in place for both sides of the contract? Those are the common parts. Lawyers are great at those last 3, promises, protections, and procedures. We are really not good at the core deal part. That's what the business owner is the best at. Some of the common pitfalls that you're going to see throughout this presentation are the ones that I've listed here in the 4th bullet point. Not having a contract, not having a signature on a contract, accepting boilerplate language without questioning it or negotiating it, not having specific enough language or clear language in a contract, and then just shit happens. People's lives go sideways, consequences follow. And that's one of the most common reasons that people end up in a lawyer's office saying, I got this contract and I kind of had to break it because things happen. So you can see here down at the bottom 2 common types of contracts that you probably are familiar with or have seen. A lease for equipment or a commercial space or some sort of, or a home. Promissory note is what someone signs when they get a loan from someone. A license is typically associated with intellectual property. If someone has copyright, for example, and they want to let somebody else make a copy of their work, there would be a license to the person who wants to make a copy of it. A waiver, we've already mentioned, it's a document that can limit liability for a business if there's a risky activity a customer's engaging in. Consent form is something that's pretty common to the healthcare industry. It's where, and we'll talk about this in torts actually, when someone has to perform a procedure or help someone medically, they have to usually touch them. And anytime somebody's going to be touched, there needs to be some sort of a consent for there not to be a tort. Thomas is going to probably talk about that, right, Thomas?
Definitely.
Sure. Bylaws are another common agreement, another common contract. Bylaws are usually a corporation. So it's the governing document for a corporation. You can also see operating agreement. That's the governing document or contract for a limited liability company. And it is literally a contract between the members of an organization, of an LLC. An NDA, we've already looked at. Non-disclosure agreement, that's for confidentiality. And then the last one is purchase and sale agreement. That sometimes comes with an agreement that there will be collateral or security offered for a loan. Those are common types of contracts. The sources of contract law, there's a couple of different ones. So state law pretty much determines, state law is largely what contracts are decided under. And there's some state statutes that might apply depending on the state that you're located in. Some of the ones I've listed here, statute of limitations, that's the statute that says how long someone has to sue after they get hurt. And it's typically associated with when they discovered the injury, not necessarily when they had the time to file it, but when they actually discovered it, the time usually starts from that point in time. There's also jurisdiction. Jurisdiction is a fancy word, just means the place, where is an appropriate place. And it usually refers to the courts of a particular place. So states can only exercise jurisdiction over people if they've made enough contact with the state, if they've done enough business in the state. There's a whole, that's civil procedure. That's another one, of course. We look a lot about minimum contacts with the state. How can you haul someone into court in that state? And where appropriate jurisdiction might be. That really applies to a lot of transactions and sales here. Case law is judge-made law, rather. That is typically, it's going to be in decisions that were decided by the courts. It's typically going to take a little bit of research. There are free places online to search for case law. Lawyers usually have a paid subscription to look it up. Case law tells us what the heck is a bargain. What is consideration, meaning what has somebody given up so that they can enter into this agreement? What constitutes an acceptance? What is a counteroffer? When does someone actually accept a deal, and when are they just counteroffering? And then case law also looks at what kinds of damages someone can get if they're asking for relief from the court. Statutory law, there's really not a lot of it. There's statute of limitations and jurisdiction one that I mentioned. There's also something called the Uniform Commercial Code, which is something that a lot of states have adopted. It's a national code, but some states have taken it in and said, okay, this is going to be our statute in our state. The ones to pay attention to are Article 2, which talks about sale of goods. There's certain, was the goods that were sold, did they meet the expectation? Were they appropriate for the intended purpose? What happens if there's failure to deliver? It can handle sale of goods to customers, or it can handle sale of goods between businesses as well. Article 9 of the Uniform Commercial Code is what applies to secured transactions. So what happens when there's collateral or security and a debt goes bad and somebody's trying to repossess that item or that home. And then everything else is basically the interpretation of the agreement. This is where folks who have commercial leases in this state run into trouble, because there's no state statutes that say what should or what can go into a commercial lease. There's no state statute saying that, for example, a business owner renting a commercial space is entitled to have a safe space to run their business out of. That is entirely in the contract. And so largely contract law is a matter of looking at the document itself, trying to figure out, is it confusing or is it clear what it means? And then if it's not, or if it is confusing, what are the circumstances surrounding it to try to figure out what the original folks who signed the contract intended to happen. That's largely everything else if it's not state law or if it's not in case law. I'm going to pause there and see if there's any questions. That was there was some legalese there. I hope it wasn't. I hope it's not too boring, but this is we love this stuff.
Yeah, this is good review. I think some folks, I don't think everyone, but some folks were here for the contracts webinar. So this is a really good review. And before we jump into torts and liabilities and insurance, oh my, okay, I'm done.
I'm going to hand it over to Thomas. Torts are a lot of what lawyers do. It's usually what lawyers are associated with.
What are torts? Can you define them? Because we're throwing this term around and it's okay, liability is great, but what are torts, Thomas?
I am so glad you asked, Wei. And thank you as always for a wonderful segue. And welcome to our new attendee. And for everyone, please, as Wei has said, you're encouraged to ask questions and have this be a conversational experience, because we really want to hear from everybody and tailor this information to the extent that we can in an educational atmosphere to what you need. That being said, Wei, you asked what torts are. They're just the classic example, I think, that we frequently think of is like a slip and fall. So say you walk into a store and there's a puddle on the ground, which should not be there, and a person slips and is harmed. That would be a tort. Because effectively the store had a duty to make sure that it's a safe place to walk. So when the person was harmed, it means effectively the store had a duty and then did not live up to it. So normally, one of the processes, I used to work at Target, for instance, if you see something on the floor, you put a sign out that lets people know that there's a slip hazard, and then you promptly as possible take care of it, or as soon as you're aware of it. And that would be, due diligence. Now, when you don't take care of it, when you become aware of it, as you can see on the slide here, that would be the negligence aspect of that slip and fall scenario. So a tort is just a civil side of things between individuals when somebody gets hurt because somebody else did not do what they were supposed to do, which is distinct from criminal side thing. And we call it a cause of action, which is to say it gives somebody a rationale or a reason for a lawsuit in effect. And the difference there being, so another tort would be assault and battery, which can exist both. I know it's wait, I saw your face. It can be a very extreme example, but I'm using it because it's both criminal, which is to say you can be tried by the state, by the government, as a criminal offense, but also the person who is harmed can sue the person that has harmed them for assault and or battery. So it exists on both sides of the scale. Really, the key distinction there is on one side, the criminal, it's always going to be the government trying to hold somebody accountable. On the other side, frequently, it's the person who was harmed, basically trying to say, I need money to cover my medical expenses and perhaps to cover any like emotional or residual damage I feel like I experienced because I was harmed in a way that was unacceptable to me. Oh yeah,
Question.
wait, go ahead.
Since the law considers corporations as individuals, can
Mhm.
corporations also like sue someone like in this way? Like, or
I
is
want to say,
because it
I,
sounds like torts are usually individual.
mhm. That's a really interesting question. I want to say, and this is, I might have to throw to Professor K a little bit for this one, but I want to say I imagine that, like, say, an agent of a corporation
Mhm.
is, uh, let's say, a courier or something is going about their business,
Mhm.
and then somebody else has like a road rage incident and just attacks them. Then the corporation, once again, going back to the assault and battery, I'm sorry for using such dire examples. The corporation could sue on behalf, I imagine, of that person. But then again, I don't know exactly how that would manifest or happen. So, Professor K, maybe you want to weigh in on this a little bit?
Oh, and Rahima, do you want to take a stab at it?
Oh, please.
No, I just had an example. So
Oh,
Taylor Swift produces a lot of CO2 emission.
Mhm.
oh,
Somebody is openly putting out that information because it's public, like who's flying in the air. So this person's publicly tracking her every time she flies.
Huh.
And she's saying that stalking and harassment. Is that technically a tort? And
Mm.
she's trying to say that she sent him a cease and desist letter and said that she was going to sue him if he kept it up. So I was like, it's
That's,
public knowledge, Taylor Swift.
yeah,
You just
right.
to tell you about it. But
I love this. This is such a great example.
yes.
So thank you, Rahima.
Appreciate it.
For Taylor Swift, stalking, it could actually be a criminal offense. So stalking is generally a targeted action that says somebody is being really unreasonable about how much they're contacting me, how much they're following me. That is criminal, technically. Intentional infliction of emotional distress is a tort. That is something that can be claimed if someone is so reckless with regard to whether it's going to hurt someone's feelings or traumatize them that they are held responsible for it. Typically happens in the context of, say, someone screws up a burial, loses a body, knows that someone's dog has just died and sits and screams obscenities at them in front of their house. Like these are actual cases. So these are how we came up with the torts. This was something that wasn't available until last century, where we developed this understanding and acceptance as a society that that sort of stuff is not acceptable and that it hurts people. So that's one thing. So intentional infliction of emotional distress, that's an individual claim. But the ones that I think are going to be most relevant to businesses, to answer your question, Wei, is something like trespass to land, where the business owns property, somebody comes onto the property and they did not have permission to do so, and they're not responding to requests to not do that. That's potential trespass to land. Trespass to chattels is just and I hate this term, is basically you take someone's stuff.
Personal property.
Or you walk onto, like you go over to someone's property and use their equipment. That's trespass to chattels. Conversion is actually where you take someone's stuff. It is the civil version of theft. So you take someone's property and you make it yours. And that could be taking a piece of equipment and making it yours. It could be actually taking a piece of property and using it as yours. There's other torts too that come into place, like it's not really a tort, it's a property claim. I'm not thinking of it. Thomas.
As soon as you tossed to me, it went out of
Yeah,
my
I know,
head.
right? Like, don't give it to me on this. Where you can claim that out for 15 years, you use the land for the same purpose and you use it again.
Yeah, where it's like
Oh,
the squatting.
Yeah, because my brain
adverse
is like
possession.
losing it right now. Anyways, to
Is
come
it
back to
adverse
the
possession?
Taylor, what is it? Adverse possession. Thank you.
Yeah.
Thank you. So to come back to the Taylor Swift example, public information, if someone like confronts Taylor Swift in front of an audience and starts screaming obscenities at her and is like, what the heck, you're just destroying the planet, right? And maybe that might be enough to say that's an intentional infliction of emotional distress. If someone takes Taylor Swift and pins her down in the bathroom or something and is like, hey, you're doing this, and then won't let her leave, that could be a potential claim for false imprisonment. for example. So it usually is an individual. It usually is not a business, but businesses do have some things where they own property and that's being hurt. I hope that answers the question. Okay. I think we were on to strict liability, Thomas.
Oh, indeed we were. I was going to just, so negligence, and then intentional torts, the big distinction there being whether or not somebody intended to do it, which is actually a good segue into strict liability, because strict liability is something that attaches to somebody when fault or when intention doesn't matter. It's basically saying there's certain things that are so dangerous that if you are to engage in them or to put out a product that exists in these specific realms, they will, and somebody gets hurt, you're automatically going to be liable. And your intent about whether or not somebody was in fact injured doesn't really play into whether or not you can be culpable or responsible for and held legally liable for the events that followed.
So
Mostly,
I want to keep going with this Taylor Swift example because like strict liability is Taylor's using explosions on stage, right? And somebody gets hurt.
yes.
If you're engaging in a dangerous activity like that, you're responsible for what happens. That's strict liability.
Mhm.
Go ahead, Riley.
Question. Okay, so I have a friend who owns some property in the state, and their neighbor just like lets their dogs run loose and comes onto my friend's property. So, and when my friend has confronted this neighbor, the man is like, yeah, and I want them to be free. I'm not going to leash them. So that would be strict liability.
Not necessarily.
Okay.
So strict liability it can be associated with someone letting their animals onto another person's property.
Uh-huh.
For that, though, there is a particular statute that says what animals is someone responsible. It's usually farm animals, cows and horses.
Okay.
And
Okay.
Yeah.
All right.
there are statutes that say that an animal that has a history of bites or aggression, somebody can be held responsible for if someone gets injured when that dog is not controlled.
Okay.
But as far as I know, and I could be wrong about this, maybe Thomas has a quick research project coming up, there's no real restriction on someone letting their pets onto another person's property. There is, it's possible to post one's land as trespass, no trespass rather. And then when that is posted, nobody's supposed to be on the property, regardless of whether they're with their pet or not. And nobody's supposed to let their pet onto the property. Yeah, that one's tricky because it's farm animals usually that are considered to be the dangerous ones that would be strictly liable if one of them got out. Not necessarily
unless the
dogs.
dogs were violent, and then
like if it was a fighting dog or something like that, right? Strict liability is tough because it's sometimes by statute. So the state says this is dangerous enough that we're just going to make this strict liability, or it's sometimes just inherently dangerous. So blasting is the common example. Toxic chemicals is a common example. Farm animals is another one that's usually regulated. Outside of that, though, typically it's just going to be regular liability, which means, and what comes into all of these is what was the standard of care? What was somebody supposed to do to not mess up? And I know you're going to talk about this, Thomas. I'm going to hand it back to you. What's the standard of care? What were they supposed to do? Did they make a mistake? Did they breach that standard and really treat someone? Did they make a mistake and someone got hurt as a result? That's the liability analysis. What was the standard? What were they supposed to do? Did they make a mistake? Did that cause an injury? And what was the injury? So that's negligence in a shortcut. Probably what's on the next slide, right, Thomas?
Indeed it is.
Duty, breach, causation, harm.
So glad. Once again, a fantastic segue.
Yay.
So back to negligence. There are multiple kinds. And so a lot of these have to do with like different states and how they manage fault or assessment of fault in negligence cases. So actually, as you can see at the bottom, those are the four elements, and I'll skip back to the top in just a second. Those are the four elements, which basically in law school or just in the law are what we call the things that have to be satisfied, the criteria that make up a specific legal idea or like crime or tort. In this case, as we've already talked about, it's duty, breach, causation, and harm. So what was the duty? What was somebody responsible for doing they didn't do? Breach, how did they not live up to it? Or, how is the like, let's say, leaving the puddle on the ground in the store? That would be the breach of the duty to keep the store a safe place to walk. causation would be somebody was responsible for the puddle. It doesn't have to be the store. But the store was responsible for cleaning up as soon as they became aware of it or notifying customers that it's there. And the cause would be them not actually attending to it as quickly as they became aware. And the harm is the person who slipped and fell. So in the example of the dog, I believe sometimes we can have a heightened duty if we're aware, per se, that our dog has a history of biting people, that we have to take greater care to make sure that our dog doesn't have access to people to bite. And maybe putting up a sign that says, beware of dog, would be something you could do to notify folks that they should stay out of your yard because your dog might like to bite people. So now I'll jump back up to the top and we can go over a little bit of the types of negligence. Ordinary is just going to be, you just made the mistake of leaving the puddle out. That's going to be negligence because it's probably going to be the most common kind of tort that we see. Gross, and this is an important one. Gross negligence is where you just display blatant disregard for people's safety. I was riding with some friends or some of my other clinic students or compadres up to Burlington for a presentation. We were talking about this, and the example I thought of was, let's say there are some people putting in an irrigation system, and they dig a hole in the middle of a football field, and then they don't put up signs or notify anybody that's there that the hole is there. And the next day they have football practice. That would be like gross negligence. Somebody's probably going to stumble into that hole, and you didn't do anything to notify them, and you didn't do anything to repair it or make it safe, like put boards over it. Anything in terms of gross negligence is going to be just, like it says here, grossly disregard safety standards. So you're going above and beyond a disregard for the common practices that would allow people to avoid the hazard. Comparative, this is just going to be multiple people caused harm. And so in the state's assessment of who's at fault, they're going to be looking at percentages of, I want to say, blame or fault. Contributory is the person who was harmed in some way, took some action that added to their injury. So a common example is somebody is driving through a green light and somebody else runs a red and hits them, but the person who drove through the green light wasn't wearing their seatbelt. So in that way, yeah, unfortunately, even though they're not at fault for the accident, the choice not to wear the seatbelt contributes to the degree of harm that they suffered, and so the state's going to take that into account when it's looking at damages and other things. Now, this last one's one that is definitely going to have maybe some play in the business world, which is vicarious liability. And that's just where we're held legally liable for the mistake or the actions of another person. Frequently, in this case, it's going to be an employee or an agent of the business who, in the course of carrying out the function of the business itself, represent the business. And so anything they do, so let's say you have an employee who's making a delivery for a pizza place, and they run a red, and they're the person who runs the red and hits the person in the car without the seatbelt. That would be a place where they're an agent of the pizza place and might then be extending liability to the. It also depends on how the person is paid and employed. But I don't want to get too far in the weeds here. Let's just say an agent of the business, somebody who is a representative or responsible for the business, it causes a situation where the business is then liable. And then product liability, this is another one that's going to be very common in the business world, is just mistakes made in the production of a widget. So either there's a flaw in the design. So let's say a folding chair that as soon as you sit down in it, it collapses on the person who's sitting in it. That would be a design flaw and something that the company would be very much liable for. But let's say, on the other hand, that the company had a good design and they sent it out, but then the manufacturer used a substandard material, something they weren't supposed to. Yeah, it's weaker than possible. And once again, same thing, it collapses on people. That would be a manufacturing design flaw, which would also create liability. And we'll be talking about labeling later, but also if labeling is either deceptive or unclear and doesn't adequately explain the dangers associated with the product, that could also be something that creates liability for the person who has put forth the product. So, any questions on any of this? Wei, anything you want to?
I mean, I do have comments, but I also want to make space for other people because my examples are probably not related to the business this year. This is really interesting. Yeah. So for businesses specifically, then it sounds like the last two examples that you give, those are primarily what they might be looking out for versus I mean, obviously ordinary could be also part of it and the other ones, but
all of these though, vicarious liability and product liability are two of the big ones, but anytime anybody has a brick and mortar, ordinary negligence is a concern.
okay.
Yeah, absolutely.
Falling ice, puddles of water, liquid on the ground, and that's generally what general liability insurance protects against. It's just things that happen in a place.
Yeah.
That nobody intends, right? Gross negligence is going to be relevant for some businesses, especially if they engage in a potentially dangerous activity. So I like Thomas's examples. They're solid. The one that I always go to for gross negligence is, say somebody runs a gym and they sell memberships to senior members, people who are over 65 who have the potential to have a heart problem, and they don't carry a defibrillator on site. That could potentially be gross negligence. They're selling memberships to folks who need the device. It's a really easy fix to have it on the wall, and failure to provide that if somebody suffers a heart attack because they're working out, that's the nature of the business, right? That's an example of potential gross negligence. Comparative and contributory are really just important when a business has a potential claim that they're like, hold on a second, somebody made a mistake too. It's not just us, somebody else is responsible. It's really to sort out who's going to pay for what and who, and like he said, percentage of responsibility. It's literally a determination of the business is 60% responsible and the customer is 40% responsible because they did this to make it worse.
So what if a business doesn't have a brick and mortar? Like if, you're working out of your home or you have an online presence.
Yeah. Then that there's usually going to be really just product liability that comes into play. Having an online presence and only selling online means that there's no physical injuries usually, unless it's a product that goes wrong. If there's no employees driving around or doing things on behalf of the business, then probably not a vicarious liability issue. People who are selling almost entirely online or who don't have a physical location, they're probably dealing with product liability. There's other things that come into play too, but that's general. It's almost safer to just sell online because there's no, except unless the product is designed poorly, manufactured poorly, doesn't come along with the right warnings. There's no real risk when nobody's physically going to get hurt.
What about data?
Yes.
So when you have an online
point.
presence, what about the data piece?
When it comes to torts, I wasn't thinking about cybersecurity. But that is a good point because it's a different claim. It's a state claim for breach, for failure to protect information. So that's generally handled through the AG's office. It's not necessarily a criminal action. It is civil. The one that's, when we're thinking about torts, it's usually not the state. It's individuals or businesses that are getting hurt, that are bringing a claim against the others. An example is OJ getting prosecuted for murder criminally, and then there was a civil lawsuit that followed it for wrongful death, which is the civil version of murder. But yeah, so we will talk a little bit about cybersecurity. We don't have a lot of data privacy information in here. That is an area where it's almost like a separate topic, which we should think about doing a webinar.
Which I think we are doing.
Oh, are we? Okay.
I think we have that on the schedule for sometime there you in the coming months or in the fall. Right. Rahima had a question, I think.
Oh, Rahima.
Oh, nice.
I think it disappeared, honestly.
Oh.
It just went.
Come back with it.
That's okay.
Come back with it. Yeah.
All right. Intentional and strict liability, Thomas.
Okay, so as we can see here, as far as intentional torts, there are 7 different kinds. You have assault and battery, which we've covered. The difference there is assault would be creating fear or the anticipation of physical contact or imminent harm, reasonable apprehension. And then battery is when it actually takes place, the physical contact that is unwelcome. So one of the first cases we look at in law school is one where it's battery with smoke. There's somebody who's on a radio show giving an interview, and the radio host breathes cigar smoke, onto the person being interviewed. And the person who's being interviewed took great exception to that, did not like it, and then filed a lawsuit.
And was, if I remember correctly, was sensitive to cigarette smoke.
Correct.
And so there's another illustration. Go ahead, take your plaintiff as they stand.
Well, I was just going to say, and the radio host was aware of that in that scenario, and then chose to do it anyways.
Yeah.
Let me see what else. Sorry, let me go back up. So then, false imprisonment is another one. Intentional infliction of emotional distress. We've already talked about this one with the Taylor Swift example. Trespass to land. That's just trespassing on somebody else's property without express permission. Trespass to chattels. Once again, that's like personal property. So interacting with it or using it in a way that is not authorized. And then conversion is, as Professor Killoran said, the taking of it, converting it to your own purpose or use, largely just making off with it. So the ones that are going to be relevant to business owner here are going to be conversion and trespass to land frequently. A lot of the other ones we hope you never see, but be aware of them just in case. I know sometimes I think they're rare examples of like false imprisonment or something, but it actually takes a lot to rise to the standard of false imprisonment because it has to be for like 24 hours or something. It varies state by state. That being said, all intentional torts have three aspects in common. So the plaintiff or the person who's been harmed has to establish three things. First, that the defendant committed the act. Second, that they had the intent to do so. It's an intentional tort, so they had to have meant to do it. And third, that the act that was undertaken caused harm to the plaintiff or their property. So as you can see here, strict liability, we want to come back around to that because it's a very important concept when we talk about products, because it basically dispenses with the intentional portion of the intentional tort. It just says if you're acting in this space, you're going to be liable. So let's say like skydiving. I've been skydiving. You have to sign a waiver that's, it looks like a phone book. I'm exaggerating, and they tell you a whole bunch of times if you do this, you could die. That being said, you're trusting them to pack the chute correctly. If they don't, they're going to be strictly liable. Because there's no waiver in the world that can make you, and we'll talk about waivers later, that can allow you to sign away your own safety in terms of your life and like say your limbs. That just doesn't work. So strict product liability, as Professor Killoran, another great example. It is wild. If you go skydiving, just be prepared for the waivers. They're very frightening.
I think we've got it on the next one, actually. On one of the next ones, we've got, wait, where's the skydiver? There's the skydiver.
Yeah, that's why I use that picture.
Whoops. All right. Wild
Oh,
animals there too. So anybody who's keeping wild animals, anybody who's
There
selling
you go.
wild animals, that's another area.
Mhm.
An
Explosions.
example.
Yeah.
Toxic chemicals too.
So yeah, strict liability. If you choose to engage in these activities or put certain products out, you're going to be liable if somebody hurts themselves. So there you go. Any questions on that from anybody? Please.
No.
Okay.
That's wild.
No. That's wild. Never going skydiving, would not want to, but thank you for sharing that. That is
It is inherently dangerous,
It is indeed.
as it turns out.
Yes.
Are you want to
And
do
to
the
fly in
entities
the
part?
air.
You want to do the entities part, Thomas? Are you doing the rest of them for the torts section?
Well, I think
Pick it up.
that's it for torts. I can go over entities. Sure.
Okay, go ahead.
Let's see here. So entities, one of the things, not a problem, Wei Wei. We'll see you when you get back. Entities are their own form of liability protection, or can be. I shouldn't say that they are automatically, because there are certain types of entities which do not extend liability protection. So when we're talking about those, we want to talk about sole proprietorships or partners, which the key distinction there are just going to be entity types that are not registered. So if somebody just goes into practice or just like starts operating a business out of their house and never notifies the state, that would be a sole proprietorship. In that case, there is no liability protection, which is to say that all of the assets of the business and all of the assets of the person or the partnership are going to be considered one and the same. So any liability created by the business is going to lead to liability shared by the owner, in which case somebody who brings suit against them can then potentially go after all of their personal property. However, the nice thing about if you were to launch or register and start a limited liability company is it's all in the name. It's going to limit your liability. So it's going to create what we call the corporate veil, or basically a legal firewall between the assets that belong to the owner and then the assets that belong to the business. So yeah, if you need help identifying, absolutely ask these questions. But we'll try to, hopefully we'll cover them as we go, just without me rambling too much about it. So the limited liability company, what it does is it creates basically a legal fiction, which is to say it legally makes a distinction between your home or the business owner's car, their home, their bank accounts, and all the things that belong to them that are not necessarily associated with the business. And then all the things that belong to the business, like the business's bank account, the business's products, the business's like a company car, that sort of thing, would all be distinctly belonging to the legal liability company. Now, that being said, that does come with a series of responsibilities on the small business owner's part to maintain the sanctity or the division between those two pools of assets. Because it's unfortunately can become pretty easy for a small business owner to pierce that corporate veil is the legalese term for it, but to kind of muddy the distinction between what belongs to what. So if let's say small business owner goes to the store and is buying their groceries with a check from the company, that doesn't look good for, to courts in terms of saying these things are different and should be kept separate. If a small business owner is using their company car to go run errands and pick up their child from daycare, something that's distinctly different from the business function itself, that's another way that unfortunately a business owner could make a mistake that would they would open themselves up to the liability that was the whole point of creating the limited liability company in the first place. And as you can see here, we just have 4 different entity types, which I'll kind of speak to now. For small business or small business owners, the limited liability company tends to be a favored business structure or entity structure because it just allows for a lot of flexibility. It also allows for pass-through taxation, which is to say it creates you don't have to be taxed twice. A corporation is going to be taxed twice because they have to pay corporate taxes, and then any profits that the owners are taking out of the corporation or making also are going to be taxed as income. With a limited liability company, it's called or they can be called disregarded entities. Basically, it just means all the profits which are going to the owner are going to be taxed as income. You can, however, elect as a limited liability company to be taxed as a corporation. That takes a special form, and it's something you kind of have to go out of your way to do. A corporation, on the other hand, you might be asking, what are the benefits of a corporation? They're heavily regulated, and they provide a very rigid business structure because of that. But the thing is, they're also designed to do things like to allow for things like stock offerings and to secure funding and investment. And frequently, that's the type of the business entity that's going to be most familiar with like venture capitalists and other people who might fund a business. They might even insist upon it being a corporation, or in fact being a Delaware incorporation, which is we don't need to go too far down that road other than to say that Delaware has some of the most recognizable, some of the oldest, and some of the most preferred business laws. Sole proprietorship, we've already talked about, doesn't extend to liability shield. Just somebody operating their home is largely going to be a sole proprietorship. And then nonprofits, I wanted to bring these up here because they, depending on how you want to operate, they can, to a degree, protect the assets of a nonprofit. It's just they cannot be owned. So everything that belongs to the nonprofit is going to be specifically the nonprofits and cannot be owned by any of the people who work for it. because nobody can own a nonprofit either in and of itself. That being said, somebody who wants to make donations to a nonprofit can use that as a write-off on their taxes, which is another way to potentially protect some of your own financial assets. But that being said, any liability that is attributable to the nonprofit is going to be attributable to the nonprofit. Oh, can you talk more about the disregarded entity? Because I'm a single member LLC.
Yeah.
I'll kick to Professor Killer.
Go ahead.
Oh no,
you
I
want,
was.
you want to toss to me? That's fine.
Yeah.
Okay. And I'm actually going to go to this next slide, and then I'm going to come back to you, Jin Lee. This is just a summary of what Thomas was just talking about when it comes to corporate veil. You can see here, this is the real important points that folks need to keep in mind. Keeping separation between the owner and the member, the owner/member and the business. So one's a human, one's a business. Making those things separate is really, really important. Not signing personally, meaning not signing a personal guarantee. So for a loan, for example, if somebody's taking out a loan for their business and from the bank, and the business owner signs as their personal guarantor of the debt, that means that they owe the debt as well as the business. That means that the individual owner, whatever assets they have, whatever money they have, if there's a collection action, that money can possibly go to the creditor. The corporate veil really is important because, as Thomas said, it maintains that liability shield. It does require proactive management. It requires active separation, especially bank accounts, but even things like if somebody's working out of their own home, doing online sales, they're still using their home as where their business is running. So the business might actually lease from the owner. It's a piece of paper. It's the same person. The business is the owner is the business, but the owner is keeping their asset, their home over here. That's the human's asset. The business is renting that. The business doesn't have any ownership in the home. That means that if the business gets in trouble or if there's a debt that gets assigned to the business, then the individual owner keeps their home, and that's not available to pay the debts of the business. So the exceptions, again, to pierce the corporate veil, to remove this liability shield and make the owner or member directly responsible for the debts of the business are if someone signs as personal guarantee, someone's personally responsible for hurting someone. The pizza delivery question earlier, if somebody's out there delivering a pizza well, let's do this. If the owner of a business is delivering the pizza and they run into a vehicle, even in the course of business, they're personally responsible for injuring somebody in that accident. If their employee runs into someone, an individual, they're responsible for the injuries that their employee caused. But that is one way to cut through the corporate veil if the owner does something wrong and hurts someone. And then failure to maintain separation. So, but you wanted to talk more about disregarded entity, Jin Lee. That a disregarded entity is what we call a single member LLC. So someone who is just a single business person and they have incorporated as an LLC. Disregarded entity is for tax purposes. And it means that one person who is incorporated as an LLC, there's no real difference between the person and the business for tax. So the income of the business is the income of the individual. It's basically as if the LLC doesn't exist, but because the person has set up an LLC, they do have that protection. They have the liability shield, but it's disregarded for tax purposes because it's the individual is the business and the business is the individual. Income flows to the individual's tax return. Expenses flow to the individual's tax return, as opposed to having corporate taxation, which is the difference. So disregarded entity is just what we call the single member LLCs. Can be, and there's a difference between that and pass-through taxation. Just wanted to clarify that. A disregarded entity is how the IRS treats single member LLCs. Pass-through taxation is an option for LLCs, no matter how many members they have in them. And it's the same idea. The income and expenses pass through the LLC. They go straight to the tax return for the individual owner. Hopefully that clarifies something, but did you have other questions, Jin Lee?
And while we're waiting, so as long as there's only one person that's part of the LLC, that's when all the taxation. But if there are two people as part of who are owners of the LLC, then how is that done? Then that's like sorry, I don't know the terms.
No, it's okay. A single member LLC is a disregarded entity.
Okay.
LLCs by default are taxed as pass-through taxation.
Oh, okay.
So pass-through taxation for a multiple member LLC is the same as a single member LLC. If they're electing to be taxed as pass-through, that means for an individual, they just file it on their own tax return.
Yep.
For a multiple member LLC, there's actually an extra filing, there's a K1. But otherwise, all the individual members do file their income and expenses for their portion of the LLC on their own tax return.
What if it's like a married couple?
If it's a married couple that's running a business,
Yeah.
I mean, it's two people. If they are in an LLC together, they're in a
So-
multi-member LLC.
And then, but then it would, if they're filing their taxes together.
Mm-hmm. They're still, so they're multiple members. Oh, that's a really, I see what you mean.
Yeah.
It's just going through to the married couple's tax return
Okay.
because they're
But
going to report each of their income and expenses.
Oh, okay. I see. So Jinli asked, so does that mean that for tax purposes, the filing will be as if I was filing taxes for myself?
That's right, Jinli. So anybody who is a single member LLC who is on that default pass-through taxation status, and that's the default, meaning somebody would have to have filed a piece of paper with the IRS to say, I don't want to be taxed like this. But the default pass-through taxation means that a single person and an LLC will file the business's income and expenses on their own personal tax return as if they were filing for themselves. Yeah, you're correct, Jinli. Okay. Any other questions on this? This is usually a big area, but I know maybe some folks have been in the entities webinar that we did before, so they've got some of those answered. All right. Labeling. Thomas, back to you.
Oh, I was, let me go ahead and,
I am happy to handle this. I thought that I'm happy to pick this up if you'd like.
oh, let me, yeah, if you wouldn't mind, and then I'll take a look at notes, and if you want, I can jump in.
Yeah, that sounds good.
Okay.
So this is just some high level view of what applies to labeling here. By labeling, this is where we're talking about having the right warnings and information on the labels that somebody puts on their product or the instructions that go along with their product. So labeling is what we call a marketing defect or a warning defect. That's a term from tort law. That means that somebody failed to put those appropriate warnings or instructions into their materials that goes with their product, and they're liable as a result. So the regulations that apply here at the federal level, Fair Packaging and Labeling Act, that's not one I'm familiar with, but I'm sure that this is based on Thomas's research. The agencies that are going to control labels are the Food and Drug Administration, the Federal Trade Commission, National Institute of Standards and Technology really speaks to the standards for technology. And then Consumer Product Safety Commission. They control things like children's toys and clothing. There's also some state regulations that come through Vermont Agency of Agriculture, Food and Markets for Vermont food products, Vermont-based food and value-added products. Basic requirements, just an example here for what folks have to put on labels, and this is not exhaustive. This is where we would be happy to do a deep dive. If anybody has specific questions about what needs to go on their labels, we'd be happy to do a deeper dive and do an individual consult to answer those questions so it's relevant for you. But you can see in general, food, there's going to need to be an identification of the type of food, the manufacturer, the place of the business, the ingredients, the nutritional information, net contents, drugs. Thomas just summarized it by saying you've seen these. It's a lot. There's a lot of specific requirements for drugs and supplementals. We're not going to get into these here.
We can go over them though.
Yeah, it's a lot.
Yeah.
Products, though, in general, there's some rules for how products can be sold, right? What is the item or commodity? So the example here, is it a detergent? Is it a sponge? Who is the manufacturer, the packer, or the distributor? Where are they located? What's the net quantity, weight, or measure of the contents in both metric and inch pound units? So those are just real basic high-level requirements for labeling. Things to watch out for are especially food and value-added products. Those come along with very specific labeling requirements. Anybody who's doing anything that is a mocktail or a cocktail or anything that could potentially hold alcohol, that is treated with a separate set of regulations, and there's a threshold at which something is a mocktail and when it has to be treated differently. It's usually like 0.5% ABV. There are specific requirements for anybody who's selling children's toys or children's items or anything that's going to be used by a child. And there are specific items or specific rules regarding clothing. So those are the general areas for labeling. I'm going to pause and see if anybody has any particular questions that we can answer in a high level look at this topic.
Can you talk more about the food piece? Because I know that we have a lot of members who might have like, they might operate out of their homes and then like maybe it doesn't quite apply because of the labeling, but if they decide to sell like an item at the grocery, or if they do, let's say a pop-up, and then they have like sauce or whatever it is,
Mhm.
like,
There's different rules for direct sales to customers.
Mm-hmm.
Usually there's relaxed labeling requirements for direct sales to customers. So think farmers market, pop-up sales, things like that. Anytime there is going to be some sort of a third party that's selling the product, so being sold to a co-op or a store that's going to be sold to the customer on that end, there needs to be labeling followed. There are some labeling requirements though for even direct to sales, direct to customer sales. I'm not sure what those are, but I know that there are a few. And it's probably going to have to do with products that are inherently dangerous, or that are going to be some of the regulated areas, children's clothing. Food is really pretty relaxed. Like you can see a lot of people who just have a label on their product and they're selling it directed to farmers market, right? The basics are, what is the thing?
Yep.
Where is it coming from? Who's selling it? And what's the weight or contents? Those are the basics for virtually any label. When it comes to particular kinds of food or particular kind of evaluated products, that's when the more specific requirements come into place.
okay. And so, okay, so what you're saying about like those direct to consumer products, whether it's food or otherwise, it's a different set of regulations.
Generally, yeah. And
Okay.
there are specific regulations for food being sold direct to
Right.
consumers. So there's a distinction as to like what is going to be a food direct to customer sale, what is going to be through a third party.
Mhm.
I just don't have that information on hand right now.
Sure.
And something else to
Yeah.
be aware of, just so you're aware, like supplements have their own degree of regulation, or their own separate set of regulations for labeling. One of the big things to be careful about there is whether or not something is being labeled as a medicine or a drug, and whether or not it's intended to be used, like say, cosmetically, or for internal use, or so something to better health. If anything like that is on the label, you know, you really have to be careful about your labeling when it comes to supplements, in terms of being careful not to put yourself in a place of liability because you indicate it's something that is going to produce an intended outcome that it may not have been like verified to have done. So just something to be aware of.
That reminds me too, anybody who's selling products or who's making claims about anything,
Mhm.
be very careful about consumer fraud. That is something that if a customer buys something or they get a service and the person selling it made a claim that there was going to be a particular result, a particular consequence, there was going to be this thing that happens, this food will result in this to your health or whatever. That's where the supplements get into trouble, because they'll claim this will improve this will decrease cholesterol, for example. Supplement manufacturers and designers cannot put that information. They cannot claim that for supplements. That's a medical claim.
Yeah.
Another example though is, you know, what's specific enough to get in trouble for making a false claim.
Oh, what about like sunglasses that claim to be okay for the eclipse?
Yeah, that's a great example.
Oh.
These sunglasses will protect your eyes
Yeah.
from damage if you observe the sun during an eclipse, right? That is a statement. And if they do not protect your eyes, then then that is a false statement. That is a claim that misled the consumer and reasonably misled the consumer. That's the standard. But let's use that as an example too. I don't think this is true, but staring at the sun is an inherently dangerous activity. So maybe you're strictly liable. Or maybe there was a design flaw and the glasses have they were designed to have just a little bit of light around the edges. Maybe that causes someone's retina to burn. Or maybe it was a manufacturing flaw and they forgot to put the layer of film. Someone puts it on, looks at the sun, and oh my gosh, I'm blind, right? That's an example of some of the other product liability claims that could be raised in a situation like that. Yeah. But consumer fraud is tricky, and it has to do with services, and it can be business to business. For example, somebody who's providing marketing and sales services to a business, and they make a claim that if you go through my analysis and you go through my program, you're going to increase your sales 3 times. That's a very specific claim, and if that doesn't prove out, that's consumer fraud potentially.
And I'm sorry, I'm just also noticing on here for the requirements, you also noted cybersecurity. So like if any of our members are selling products online, that labeling also has to be on their online platform, or
Cybersecurity has to do with collecting people's personal information.
Okay.
Um, so that really applies to anybody who's selling online and keeping customer information, as opposed to using a third-party vendor, using an Etsy or using a like using Etsy's the big example, because you got people who are doing homemade goods and then they're selling through the platform, but the information for the transaction is kept in Etsy, and Etsy's data privacy policy attaches to that, and they've got all the protections in place.
So,
But the person who's making home goods doesn't have that in place, and so they sort of ride off of Etsy's cybersecurity policy.
but if they don't have, if they're not selling via Etsy and they're selling via their own platform, so
Yeah.
let's say, as an example, I know this is different, but like, let's say VTPOC, we're selling things on our website, then, and it was directly coming through us, that would,
Mhm.
what would we need to, would there be specific language or?
Right. So say VTPOC was selling a firecracker.
Okay, yes.
VTPOC firecracker, right? There's potential for strict liability there, but that product would have to be sold. So this is where terms and conditions come into play. So think about buying anything online. You go through with the sale and there's something that pops up before the sale completes that says you must agree to this before we proceed. That is the terms and conditions of sale. So it might say product is sold as is. Product carries the potential for risk of injury. By clicking here, the customer agrees that they are waiving liability for the person selling this product, that if they follow the instructions appropriately, that they will not be injured, and that they waive liability otherwise, they're accepting the risk. All of that can be put into the terms and conditions, that just a click to agree before the sale is completed. That's typically where it happens. And that and product liability can flow from anybody, whether they're can hit anybody, whether they're selling online or selling direct to customers. It's really about, was it designed appropriately? Was it manufactured appropriately? And was there appropriate labels and warnings put on it?
And then what precautions does like the business owner have to take in terms of the data? Thinking about the cybersecurity.
Yeah.
They're the ones holding it. If it's through their own website and it's not through like a third party, like Afterpay, I imagine is like they're holding the data, etc.
Etsy, Venmo, PayPal typically is going to hold that information securely. A business who is retaining client information, customer information, keeping it in their own system or on their own computer or on their own website, they should have a data privacy policy that says what happens with that information, what is kept, how is it kept, what is not kept. Anytime anybody keeps customer information, name, address, especially credit card number, any of that is personal information, and that's what's regulated. So somebody accessing that information without permission, that is a breach, and that could potentially, if enough people are affected by that, I can't remember the threshold, but it's somewhere in the 6,000 range. Might actually be 10,000, but if enough people are affected by that breach, say somebody gets a spreadsheet with a bunch of credit cards on it, or somebody hacks into the website and gets the payment information for the customers that have purchased through that website. If enough people are affected, that's potential action by the AG's office. It triggers a lot of requirements. It's anytime any business is handling personal information, they need to be very careful about where they keep it, how they keep it, what protections they put in place, what data privacy policies they're going to have to say what happens with the information. Then they have to follow the policy. And there's a lot of things that happen if there's a breach. Real quick requirements to report to customers who've been impacted, report to the AG's office if there's enough people who have been impacted. Cybersecurity insurance is intended to protect against all of this whole mess. It's intended to help people who figure out what their data privacy policy should say. It is intended to help if they're breach and fallout from that. Cybersecurity insurance, people who are providing it will often have best practices for a business to follow so that they can keep the information secure. It's a very tricky area, and it's something that most folks, it's not really even on their radar.
So go ahead.
Oh, I'm sorry. I just want to say, and specifically where it comes to labeling, a lot of where the NIST, I was just doing some research, weighs in on this, or they've been directed by a presidential executive order to improve labeling largely around the items that are called Internet of Things, which as directly result or relates to cybersecurity, which is like smartwatches, anything that's designed to connect with the internet and capture data presents a liability. So that's where that came in as far as labeling.
Yeah.
So for any of our members who are operating online, is cybersecurity insurance something they should be considering?
Yes.
That was really definite, y'all.
Yes.
That was like a no beat
No,
skip.
no
Like,
word.
okay, just
Yes.
talk to your insurance agent about getting
Yes.
cybersecurity. And I know this for a fact, everybody, that is separate from your general liability. Like,
That's correct.
Yeah.
That's correct. It's a separate
just learned this.
policy. Be aware it can be expensive. It's so anybody who is selling online, yes, they should have a cybersecurity policy. There is a, however, if they are selling entirely through a third party platform, if they do not keep customer information at all,
Yeah.
then that's different. If they keep any customer information, they should be worried about having a data privacy policy and cybersecurity insurance.
Okay.
Yeah.
But if they're not selling anything, they're not taking any data, it doesn't matter. Not that it doesn't matter, but that's not worthy of cybersecurity insurance.
Might not be, but even like think about selling somebody who has people coming onto their farm buying apples, right? Maybe they keep a customer list. And there's a couple thousand people on the customer list, and they keep that because they really want to reach out for marketing and to get them to come back, right? They have personal information. They have the person's email address and their name. That's personal information. Anybody accessing that data, that information without permission, that's a breach of cybersecurity. I know.
That is a great example.
Yeah.
That's, yes, helpful.
Not just online sales, but customer lists. So just
Okay.
like a spreadsheet of people
Any-
you want to
yeah.
send a marketing email out to. That's personal information. Has to
Right.
be protected.
Right.
Yeah, it's tricky. And it's scary. We will do a separate webinar all about cybersecurity, and I'll bring in our team expert, Jeannie Ikes. She's a national expert on this stuff.
It's awesome.
Okay, waivers. We've already talked about this, so I won't go too deep on it. This is what someone signs if the business wants to minimize the risk that they're going to get sued for something that the customer is doing. Typically going to see it in places where there's an inherently dangerous activity. And I'm not talking about like blasting or toxic chemicals. I'm talking about things where somebody could get injured. So think about a personal trainer going to someone's home, helping them work out, helping them manipulate their limbs, or if they've got an injury already that they're trying to work with. That's a potentially risky activity. I would recommend that personal trainer have the customer sign a waiver that says, I understand we're going to be moving our bodies and doing things that might be a little uncomfortable. If I get injured in the course of that, I'm not going to sue you, personal trainer, because I decided to do this activity myself. Waivers really need to be clear. They can't be confusing or misleading. They need to be in very clear language. There needs to be a clear description of the activity that's being entered into. There needs to be an acknowledgement on the customer's part of what risks they're undertaking by doing that activity, and it has to be very specific. For example, say somebody is doing weddings on their property and they got some steep cliffs that people have to avoid. Maybe a customer coming on, or maybe somebody is going to be coming to a wedding venue, or more, even better, the person, the bride and the groom, the person who are arranging the wedding, have to sign a waiver that says if any of my guests ignore the signs and step off the ledge and get hurt, I'm not responsible. You're not going to sue me. Or you agree that you will actually come in and defend me if one of your guests comes in and sues me. That's called an indemnity clause. But there has to be a specific detail in terms of what the risk is. In that circumstance, it would be by agreeing to use our venue for your wedding, you understand that there are cliffs and ledge that people could fall down and get hurt, and you agree to not to defend us against a lawsuit if that happens. So the rights that are being waived is usually the right to sue, or the right to go into litigation about an injury, the right to sue for a tort. And then they do have to be as specific as possible. Those are a good tool to minimize risk though. Okay, insurance. I know we wanted to get to this one too. I think we've got a couple more after this, but they have to do some other topics. Insurance really is a way to guard against the unknown, as the slide says. I like to tell people this because it is a free resource. Talk to an insurance agent. You mentioned that earlier, Wei. Talk to a cybersecurity and talk to your insurance agent, maybe add a cybersecurity insurance policy. Typically, insurance agents want to sell you everything, so be careful about that. But they also, insurance companies have people devoted to finding out and measuring the probability of everything that could potentially go wrong. They create these things called actuarial tables that gives the likelihood of something going wrong. And that is how they determine what to insure. So largely the conversation with an insurance agent to set up a policy is about what risks the insurance company might see in the person's activities or in their business. That is often a conversation that is free, that can help someone figure out where their own risks are. So if you're talking to somebody about a cybersecurity policy and they're asking if you have a customer list or if you keep customer information, that's a good first step to say, oh, maybe I need to think about keeping customer information or keeping a customer list, right? They also might have a list of best practices. If you're insured by a particular company, they can sometimes send an agent in to say, these are the best practices that we want you to adhere to. This happens in law firms a lot. We have a lot of policies and procedures that we need to follow in order to keep ourselves ethically sound, treating people well, treating our clients well, and also for the insurance agents or for the insurance company to be able to come in and say, okay, you got a malpractice suit. Did you take the steps that we recommended that you step to protect client information, to make sure you have a good fee agreement, et cetera? That is a service that the insurance company will provide to make sure that the people who are insured don't cost them any money. So again, potential free resource. You can see the different types of insurance here. General liability, we've already talked about. Slips and falls, things that usually happen on premises in a brick and mortar location. Somebody's who would reasonably anticipate that they'd get injured. Falling ice is another common example. Malpractice, I mentioned. This is really for some of the regulated professions, lawyers. Healthcare is a real common example of it, but doctors, lawyers, there's some potential malpractice that could flow to things like massage therapists and things like that. Malpractice insurance is what's intended to protect against those kind of claims. So somebody doesn't know when they're going to make a professional mistake. If they're a doctor or a lawyer, they will make professional mistakes. Someone could get hurt. That's why the insurance is there. The insurance company will come in and defend against the malpractice claim. Errors and omissions usually has to do with corporate or business officers or members of the board who make a mistake doing something in the course of governing the business. It can also apply, though, to people who are doing, for example, I saw an errors and omissions policy that played into a production company, somebody who was producing a film, and the errors and omissions policy was intended to cover if they failed to get a waiver, or if they failed to get a license from the person who was covered in the film, that their face was shown and they didn't get signature from that person. Well, that's an error, has to be covered by insurance if there's a claim. Flood policy, I really want to emphasize this, especially in light of last year's floods. A flood policy is an expensive policy, but it is specifically to protect against flood damages. And as most folks probably learned last year, flood damages are almost uniformly excluded from most insurance policies. They will not be covered. That's why there's a separate policy. There's a business income insurance policy, which is, as it implies, it's intended to replace lost income if there's a problem that disrupts the business. Cybersecurity insurance, we talked about financial losses in the event of a data breach or a cyber attack. And then there are some industry-specific policies that come into play. Again, here's where if you're in an industry where there's some risk in the activity that you're doing, there's likely going to be a policy or an insurance agent will say, this is the kind of risk we anticipate with this kind of work. How you're handling it? What are your processes? What are your signage? What is all of that stuff? For example, somebody who's doing blasting probably has pretty darn good insurance because they're strictly liable for injuries. And I tell you who's got pretty good insurance, I bet Taylor Swift has really good insurance.
What about people who are like if a client is coming to their home or something like that, like how does that change?
Typically, someone insures their home and things that could happen with their residence with a homeowner's policy. Okay. Somebody who is operating a business out of their home, it really ought to talk to their insurance agent about getting a business rider or getting a separate business policy. That is another thing that could separate the owner from the business themselves for liability purposes. Is look, here's my home. It's protected by a homeowner's policy, and the business activities are protected under a business owner's policy. Same. And here's a lease that says that the business is renting this space from me. It's my home, but the business is renting it. All those things separate them. And it's going to be a separate policy.
So, okay, so like maybe within what they already have for their home, but so for general liability, at what point should a business get general liability insurance? Because like, I'm asking that because if somebody's operating out of their home, let's say like I'm making like face cream out of my
Mhm.
home. Do I need general liability or can I be covered by that business part? Like,
That's probably going to be a policy. Maybe there's a, that's probably going to be a product liability policy, honestly. So there can be policy specifically for somebody who's generating products. If there's no physical premises liability, that's usually what general liability is for. If there's no physical premises, no brick and mortar, no one's coming into one's home, it's usually going to have to do with the product. So it might be a specific policy for supplements and nutritional stuff, or it might just be a policy that for anybody who's making value-added products or something like that.
what
And I can,
about, oh, go ahead.
oh, sorry, wait. I was gonna say I can speak to this a little bit. I used to be an insurance agent. I used to sell
Oh,
insurance.
did you really?
Yes, I worked for
I learned
USAA.
this in the first
I didn't know
contracts
that.
webinar, and I was like,
Yes.
Thomas has worn
hello.
many hats in his life.
Unfortunately, unfortunately, I don't know. But the example I was going to give, so for insurance companies, you really just want to make it easy for them to validate or to honor your when you file a claim. So if they feel like they can rate for it, often they're going to feel more comfortable actually saying, okay, we'll go ahead and honor this claim. A good example would be, so if you live in a household with multiple other people, and you let somebody use your car on occasion, it would be covered by your liability policy as a permitted user. Now, that being said, the insurance company still wants to rate you against your driving record on the vehicle, and that's going to be the basis for how they formulate your rate. So if somebody else is using your vehicle all the time, that at a certain point eclipses permitted use, and they would become then somebody who's supposed to be assigned to the vehicle. And the insurance company might not honor a claim if they come to find out during the course of a routine investigation that that person has become either primary user or like a co-equal user, because at that point they will take the position that they weren't adequately charging or rating on the vehicle, or at least rating correctly, to cover the risk associated with that other user. Because if they hadn't then factored in that person's driving record, they wouldn't have been charging you for it.
Right.
So it's the same thing for home use. If you, I would say and once again, this is a general thing, you always want to talk to your insurance company because they're the ones that are going to have to pay the claim. They're also the ones who are going to say whether or not they're going to deny the claim. So if somebody comes to your house occasionally to buy a product, even though you're mostly selling online, probably, once again, talk to your insurance company, probably going to be okay. But if you're having people come into your house all the time to buy products, at that point, you're actually having a degree of traffic, which probably would substantiate them saying you needed to have a policy to cover this specifically.
I have a couple of questions, but to that, how would they know?
They'll do an investigation. They will, there's something called subrogation too, which we don't necessarily have to get into, but let's just say insurance companies will go after money. That's
Yeah.
why, that's one of the nice things about having an insurance policy is if you're liable, or let's say if you're not liable, your insurance company's going to try to find out.
Yeah.
If somebody else is liable, they're going to go after them for you. They're going to get that money. And they're going to protect what's theirs as diligently, and they have a lot more money to do so. They have armies of lawyers that they can dedicate to making
It's
sure they
true.
aren't paying a cent they don't have to.
I used to be one of those lawyers.
So basically, don't fuck with Nicole and Thomas.
Well, no, it's okay. And like, I mean, no, don't please. But like
Yes.
this is take insurance seriously.
Mhm.
To answer your question, wait, they find out because somebody slips and falls while they're buying product in your home, and there's a claim.
But couldn't you just
So
say that, like, oh, this is a one-off? Like, I don't have people come in all the time.
there is such a thing as insurance fraud,
But
which is very risky.
And they have investigators they will deploy to go out. Like the whole actuarial science is itself like it's
Yeah.
insane how much insurance companies have like fine-tuned the ability to
Yeah.
assess risk. And then in the advent of a claim, if they come to suspect at all that there's something untoward about it, they will deploy investigators who will go out and do things like canvass neighbors, talk to other people to try to assess, is this something that's been happening all the time? I mean,
And
there's
they reserve those rights in their
Mhm.
insurance policy, which is a contract.
Absolutely.
So,
So this is, I asked that question not to like, for people to consider insurance fraud,
no.
definitely not.
no,
And also as like people of color, let's not go there. Let us not, bring those eyes onto us. My second question is, so we've talked about like in your own home and like if you have a brick and mortar, what if somebody's going into another person's house, like a client's house as an example? So let's think about like we have members who are caterers and they might go into somebody's house, or we might have someone who's offering some other service going into someone's house.
mhm. There's where typically what's going to happen in that situation is the caterer or somebody's going to the person's home has an agreement that the customer or the client has signed. And typically in that contract, it's going to say something like, I will be entering into your space and bringing food. You agree that I will not be responsible for X, Y, and Z damages, or if there is something that happens in the course of doing this, that you're responsible for those. There's certain lines that can be drawn. It's essentially a waiver that's part of a contract.
Is that the same for like a business that's offering massage or like hair services or nail services?
Nail services, hair services. This is what I see often. Someone will have like a sign up online for these services or reserve your spot online, and there will be a terms and conditions that has to be clicked before that spot is reserved. More traditional, like walk in and get services, no, there's typically not going to be anything in place and no one's going to sign anything. Events, there's usually an agreement, usually a contract that gets signed, and anytime there's a contract, how liability is going to be handled should be put into the contract. Absolutely. If someone gets hurt, what's going to happen? And who's responsible for it?
Especially if it's at the client's house. So
Yeah.
in all those cases, like whether it's food or massage or hair or nails at the person's house, that's what we're
Yeah.
talking about.
Yeah. It's regardless of the location, what the person who's doing this activity needs to think about is it risky? Could someone get hurt? And if someone could get hurt, what do I need to put into place so that the person who could get hurt understands they're taking a risk? Or what can I do to protect myself so that if something happens, that at the very least that my assets are protected if something unexpected happens.
And it would behoove the small business owner who's doing the providing the services, like they say in the massage, you cannot count on a homeowner's insurance, like the inherent liability there, to cover something that is outside the scope of the normal affairs of the house. So like a masseuse coming in and providing massage is creating a window, a basis for liability by doing something that isn't in the normal, functioning of the household. And at the point at which they create that opportunity for liability, the homeowner's insurance is going to be like, nope, we're not covering if you get hurt. At least, and there's also something like called primacy. So the masseuse's insurance company is probably going to be, if there is something, insurance companies will wrestle it out between themselves to see who has to pay.
Yeah.
It just always behooves a small business owner, if you're going to somebody's house, to make sure you have coverage that's going to cover that going to somebody else's space.
And that usually is going to
be
mean, like Thomas said, not depending on someone's homeowner's policy, but having a separate policy that
Do not
covers
do
that kind of
that.
activity.
So would that be an industry specific policy then? Because if they don't
Good.
have a brick and mortar,
Right.
like they don't, yeah.
We'll say somebody is going to be going to someone's home to do massage. They talk to an insurance agent and the insurance agent says, okay, we'll give you this general policy because there's potential for injury here. We're going to add a rider on for massage.
Yeah.
Because the act of massage there's inherent risks there for somebody who gets an injury. Have a massage rider that spells out specifically what activities, if there's an injury, will be covered under the policy.
Okay.
Or have, maybe, I don't know if this is true, but maybe there's a rider that company puts onto it for anybody who is entering into a customer's home. There's inherent risks there, right? It
Yeah.
really, like the insurance policies get pretty specific. And if there is a separate activity that is not anticipated or not usually in the course of business for that particular person, then that usually means a separate rider, maybe a little bit more on the policy costs to cover that potential risk.
Yeah.
And would that also cover the individual who's entering into the client's home? Like meaning like not if they did something or the act of what they're doing, the purpose of them going into the home,
Right.
like hurt somebody else, but like if something happened to them inside the home,
Right.
that was not a result of things that they were doing.
So the massage
could that
therapist getting hurt in the home,
Yeah.
that
Oh.
might be, so that's where this is the example that Thomas gave, homeowners insurance is only going to cover the normal household activities.
Oh,
So if this is, and it's possible that the insurance company would cover, a masseuse coming in and getting injured, slipping and falling or something like that. That's not really something that a homeowner's policy anticipates.
mhm.
So it's possible it would be denied. I don't know. That's a really good question though. Do you have any input on
mean,
that, Thomas?
Well, I will say, because that's specifically, I was in the PPC, the personal property, or CPC, casualty and personal property. So homeowners and policies do anticipate guests or people who are non-family members. That being said, it would really depend on, and I think the insurance companies, and once again, this is generally speaking, I don't want to give anyone specifics because you always want to talk to your insurance agent, but I would say, if say the masseuse walks in and there's, once again, let's say a puddle on the floor, and they slip on the way to the room where the massage is going to be carried out, that might be something the homeowner's policy, liability-wise, would kick in to cover. That being said, you don't want to count on that. If it's something that's happening because the masseuse is doing in order to pursuant to their livelihood. So something they're doing during a massage, that's going to be something that probably isn't going to be covered. And a lot of times it depends on just how random or rare it is. But a puddle on the floor is probably going to be something the homeowner's policy might go ahead and cover.
Right.
Just
So-
because they have liability built in.
Someone going into a home, as a massage therapist going into a home, getting injured, that's probably homeowner's policy. Someone going into a massage therapist going into someone's home and say like the client like kicks them accidentally during the massage and injures them. I'm sure that's happened. That is potentially a separate policy that the massage therapist also holds if they get injured in the process, right?
Yeah.
I'm not sure, but that would be, I mean, it's supposed to cover people who get injured because the business does something, and often people who get injured just as a result of being associated with the business. But different policies sometimes.
Thank you for going with me on that.
Yeah.
Yeah.
That's a good question.
There's always good questions.
I just want to make sure that like Jin Lee, Kim, Sheila, if you all have questions about this, feel free to DM me or to drop things in the chat or just come off mute. Just want to remind y'all that there is a space for that. And we have about 20 minutes left of the webinar, just so you all know.
Okay. I'll pause. Are there any questions right now about anything that we've covered? Okay.
Yeah, I don't see any.
Let's talk about debt. Yay, debt. Different kinds of debt that you can see on this screen. There's a kind of debt that you anticipate that just happens immediately when you purchase goods or when you buy something on credit, right? Line of credit is just buying something that you're going to pay for in the future. Overdraft fees, those are immediate debt. Ongoing debt, you can look at things that like contracts that take a long time to complete. Leases, commercial leases are something that's usually 3 to 5 years, or a license, which usually covers a span of years to be able to complete. There again, if someone has a contract that is, and the contract covers services that are supposed to be delivered over the course of for over a year, that has to be signed. Future conditional debt, you can see some examples. There's things like stock buyout that could happen at some point in the future, and equity cash out. Operating agreement is in here because that's usually where that language sits for an LLC at least, or liens, mortgages, UCC1. These are security instruments. These are things that are filed either with the land records or with the state that say that a particular piece of equipment or a particular piece of property owes a debt, and that debt is secured by the property. Errors and omissions, that's another kind of a debt that so this is what we're talking about basically. Liability when someone breaks a contract or when someone gets hurt, a tort. What do debts and business entities have to do with each other? We've already gone over this, but I think it's worth going over again. Sole proprietorships, unofficial partnerships, they're unincorporated. That means the owner's assets are the business's assets, and the creditors can take the owner's assets for the business's debts. We've talked about the liability shield with LLCs, partnerships, limited partnerships, corporations, including nonprofits, limited liability protection. And remember those 3 exceptions to the corporate veil. If the owner or member is personally going to be responsible for, if the owner or member is personally responsible for hurting someone, then they're responsible for that debt, not the business. If the owner or member doesn't separate themselves appropriately from the business, they might be responsible. And if they personally guarantee a debt of the business. There's a difference between what we call secured and unsecured collections. And full disclosure, I used to be a debt collector, so there you go. I know this is what I did before I came to the law school to teach. Collections, the options for trying to collect a debt that is unsecured. And by unsecured, I mean there's no home, there's no equipment, there's nothing that's making it, there's nothing offered as collateral for the debt. This is just money that's owed. Options for collecting an unsecured debt generally are asking someone to pay for it, either by phone or by letter, asking them to do it voluntarily so that you don't have to file a lawsuit to collect. There is the option of filing a lawsuit if someone is owed a debt. And once a lawsuit is filed, if the folks go all the way through and can prove the merits, they get a piece of paper that's a judgment, and the judgment can be used to collect the debt. Also an option to report if someone owes a debt. It's possible to report on their credit report that they owe that debt to a business. There's generally these sorts of debts don't make it into court. They're almost always resolved outside of court. So this is where things like negotiation, just trying to work out some sort of an agreement, mediation where a third party comes in to work out an agreement, or arbitration where it's more like a court process, but it's outside of court where there's a panel of people making a decision on the merits of a case. Those are some of the options. That's usually what folks do to resolve some of these debts. If they do go to court, there's two options in Vermont. Small claims court is for claims that are up to $5,000 total, and that $5,000 includes attorney's fees and costs. So up to $5,000 total damages. It is a simple process. It's quicker. It's generally going to get a result pretty quickly. It's DIY friendly. Folks who file a small claims case are usually going to be able to represent themselves adequately in court. The judges are specially trained to be able to help folks who need support. The rules of evidence don't apply, for example, so there's no quagmire to navigate there. The alternative is superior court, where there's no cap on the damages, but it is a complex and formal process that generally benefits from having an attorney representing someone. I want to pause here and let everybody know, though, that if a business is incorporated, and as an LLC or a corporation, for example, the business owner cannot represent the corporation or the LLC in a lawsuit. They have to have outside counsel to represent the business. It's specifically in the statutes that says that the owner or member cannot represent the entity, the business entity themselves in a lawsuit. And then collecting judgments, if you're lucky enough, well, not lucky enough to have a debt that's owed to you, but if you get through the process, you get through the court case, there are some options to collect judgments. That's going to be garnishing one's wages or bank account. So this is where after the judgment is entered, someone files a piece of paper that says, I know they bank with US Bank and I want to have the money in their account. If the collector is lucky enough to have that information, the court will authorize a process that freezes the debtor's bank account, takes what's in it at that time, and gives it to the creditor. Garnishment of wages is something that's an option. The creditor who's owed the debt, who has the judgment, can send a piece of paper to the court to authorize every pay period for a portion of that person's wages to be withheld and sent to the creditor. That's a wage garnishment. There's also the possibility of recording a lien on property. Anybody who has a judgment from the court can go to the land records in the place where the debtor owns property, and they can file a piece of paper that says, if this property is sold, I get paid out of the proceeds. That's what a lien is on property. There's also the possibility to do a till tap. This is something I didn't do too many times in collections, but it's possible to say, hey, I have this judgment. This person has a place of business. Sheriff, walk in, open up the till, take the money, give it to me. That happens.
Like the safe, like open up the safe.
Open up the till and take the cash from the till and
What's
give
a
it to the
till?
creditor. A till?
Just register.
I feel like I'm in the
register?
like 1600s. Like, what the fuck is a till? Excuse me.
It's a register. Somebody has a register.
Oh, so like your like POS system, if you have
Yeah.
cash in it, it's like, okay. Oh,
Yeah.
how do you do that now if everything's digital? Like if you're receiving it?
If everything's digital, there's no till to tap. But for somebody who has a brick and mortar and a register and they keep cash in their register, can tell the sheriff to walk in and take it.
Very old school.
Yeah. So that's the options for collecting unsecured debt. Secured debt is a little different. This is where there's some specific rules that come into play. So I don't know if you guys remember, but there is a particular set of statutes called Uniform Commercial Code. This is Article 9 for secured transactions. A secured debt, again, just means that something was put up for the loan as collateral to encourage the lender to lend to that person. The mechanism that we talked about for securing a debt is a mortgage that's filed with the land records or a lien that's filed with the land records. There's also the equivalent for equipment, which is called a UCC1 that's filed with the Secretary of State. It's harder to collect secured debts because there's particular processes that have to be followed, but the options in general are going to be for personal property or assets. There's a repossession option. So think about a vehicle and somebody bought it with a loan. The loan documents themselves give the lender the ability to go in and take the vehicle wherever they find it if the debt is in default. That's the repossession. When it comes to, though, bigger pieces of property or secured property, there is a process to foreclose on that security interest. So a home is an obvious example. Somebody owns their home, they can't pay their mortgage. The mortgage company will initiate a foreclosure action in court, which gives which lets them say how much is owed on the debt, and will give the homeowner a period to redeem the property, to come up with the back pay that's owed on the mortgage. If they can't redeem it, if they can't pay it up to current, then the mortgage company will come in once they're given permission from the court and auction off the home, sell it, and apply the proceeds to the debt. And then whatever's left owing, the homeowner still owes that debt. That's foreclosure. Yes.
And so you want to have a LLC to prevent your personal property from being put into those situations.
So that's a
They
great
just
way
take
to tie it back.
away.
Yes, they take away. That's why we say assets should be kept separate. So someone's working out of their home. They own their home. It's in their name. It's not in the name of the business. And they're leasing their home to the business. It's not the same. And they didn't sign personally on the debt of the business, or they're not personally responsible on the debt of the business. Nobody can go after their home in that circumstance to take money to pay the debt of the business.
Like they could take their computer if it was bought with company money. They could take the printer, but your home would be safe. Keep that in mind. That is like the biggest thing that I've learned from Nicole, even outside of this session today. It's like,
have a business entity
and your family.
Keep it appropriately separated. Don't sign personally for a debt of the business, and try to not be personally responsible for a debt of the don't hurt people. That is how one protects one's personal assets from the debts of the business. Yeah. The process in general, you can see the property is generally secured, or in the case of a home, somebody gets to continue living in their home while there's a foreclosure process going on until the court issues a writ of possession, which says that the lender gets to come in and take possession of the home or the property. Usually it's sold at auction for fair market value, and then the debt that's left owing after that sale is collected against the business or the owners, depending on who owes it. Jin Lee has a question. Commercial kitchen is on her property, stores online. Customers will be coming to my place to pick up my products once or twice a month. General liability insurance policy, is that sufficient, or should I be getting to an additional policy? I would say, and again, I can't offer legal advice here, but Jin Lee, that would be a perfect example to talk to an insurance agent, have a free conversation to say, and even maybe this is what I would suggest. If you're insured with one company, maybe talk to a different company about what they would cover, so that there's no trail there, right? Talk to a different company, say, this is what I'm doing. I have a business. What kind of policies do I need to protect myself? And then they'll try to sell you every policy under the sun. But that's where we say, like, have a free conversation with an insurance agent. They'll tell you what the risks are in that particular line and what you might need to protect against.
So would she talk to, in that case, using that example, like a commercial insurance agent, or like a similar agent that would be like for home insurance?
Typically that's going to be different people within the company, right, Thomas?
So okay.
Usually the same company is going to say, okay, well, you got commercial insurance questions, I'm going to send you over to my colleague.
Okay. So like if she had State Farm, then she might want to talk to Geico or something like that.
Sure. Or Geico has a homeowner's policy section and they have a commercial policy section.
Right. Yeah. But in terms of like, instead of talking to the people that she
right.
Yeah.
Yes.
Yeah.
Okay. I see what you mean.
Yeah.
If you're insured with Geico,
yeah,
maybe you talk to USAA and ask the questions that you would have asked Geico before you go to Geico. so
Okay.
that there's no trail.
And this is just a general, I would say, Jalen, and once again, I don't want to get too specific, but if you're already anticipating a certain number of customers to come through, that sort of thing, like permissive use is the whole idea is that it's not something that you're necessarily going to have any plan for. It's not foreseeable, and you don't understand how frequently it's going to occur. If you know or anticipate there's going to be a certain level of traffic, that could be something that's setting you up to potentially have a claim denied because the insurance company might be able to say, well, you knew this was going to happen,
Mhm.
and then you didn't write appropriately for it. And then just a general insurance tip. This is for people who don't mind doing a little extra work. If you are willing to play insurance companies off each other, if you switch your car insurance every 6 months, you will save money.
True.
Absolutely.
Thank
It
you,
takes a
Thomas.
little extra work, but it might be worth it. I don't know.
Interesting. So sorry, so in an example like what Jinli is saying, she's got her business at her home, she's gonna have people coming in. Number one, she should maybe create a lease between herself as the homeowner and herself as a business owner. Things like that.
That's if she, and I don't remember if she was actually incorporated. First step is to incorporate, file an LLC
Right.
corporation, really.
Incorporate.
So, and after that,
Mhm.
it's separate bank accounts.
Mhm.
It's an agreement, a
Mhm.
lease. Yeah, you are. Okay, great, Jinli.
Right.
Be incorporated, have some sort of a separation, separate bank accounts between the individual and the business, have documentation that shows that they're not the same person, right? Anytime that's confusing about who owns what, that's where the problems come. Maybe even possibly, this is a tip I offer anybody who has expensive equipment that their business depends on. That equipment becomes the most important assets for that business to continue. And that equipment can be put somewhere else. So there can be one LLC for the operations of the business that handles any of the problems that come up in the course of operations. There can be a separate LLC that holds the assets and keeps them apart. The assets are leased to the first business that handles operations. So the example is we always use as an excavator company. That business is not going to run if they don't have those excavators. That's the primary asset. But if someone gets hurt in the process of doing excavation on a site, that's a potential claim against the business. So they'll have an LLC that handles operations. So that if somebody gets hurt in the process of operating the equipment, that debt goes to the operations LLC. And the operations LLC doesn't have assets to cover that debt. There is a separate LLC over here that is unreachable for the debts of that other LLC. The separate LLC holds the assets outside of the reach of the other LLC. Does that make sense? It's a trick. It's a legal fiction, but it's separating the two. And it's saying, this is the one that has all the really important, valuable stuff that the business depends on. And this is the one that's handling all the crap that happens when the business is running. And they're not the same.
This is how like the Rockefellers, like all these old like rich people, that's how they get around all this shit, y'all.
Yep.
So
true.
this is really great advice.
Take
Yeah.
advantage.
Mm-hmm.
Do we want to touch on bankruptcy real quick?
We got 4 minutes. I
We can
want
do
to make
this.
sure that people saw my chat. Please give us feedback because we're always trying to improve our webinars. Nicole and I are always thinking of other topics that people are interested. If you want us to do a deep dive into any of the topics today, please leave that in the evaluation form. Also, you can tell by the webinar today that Nicole and Thomas have so much information, and there are other people that they work with as well. So please reach out to them for a free consult. They offer free education. Nicole's always teaching me something new. And then you can also be directed to 10 hours of free legal service, an actual 10 hours of free legal service, which is actually quite a lot if you think about it.
It gets quite a bit done.
What's that?
I said it gets quite a bit done, and we'll find the attorney for you.
And if you want to ask Nicole, what is the best way to talk to a lawyer so that I can maximize those hours? That is also something that they can help you with.
Yep.
So definitely encourage you. I wonder if we could save the bankruptcy stuff for maybe another webinar, Nicole.
Oh
Because
boy,
we
yeah,
are
it's a
at
separate
time.
webinar in and of
Yeah,
itself.
that's big because I mean, awesome.
I can boil it down if you want me to
Yeah,
and give high level
that'd be
review,
great.
and then we can do a separate one. I think it might be worth it. We actually have a couple of recordings for a deeper dive on like a 2-session webinar bankruptcy look.
Yeah.
So just want to make sure folks understand bankruptcy is intended to be a system of relief. It's not intended to be a system of shame. It distributes assets to creditors when someone can't pay their debts. And it specifically gives people who are in debt the ability to pause, to breathe, to get a fresh start. It's a blank slate. It is a humanitarian set of statutes. It really is. So debt in a bankruptcy is sorted by priority, and secured debt goes over unsecured debt. There is also something called unsecured priority debt, which is things like alimony and maintenance, child support, employee wages and benefits, and tax obligations. Those take a higher rank. Those get paid after secured debt, but before unsecured debt. Unsecured non-priority debt is basically everything: credit cards, medical debt, personal loans, things like that. There are a certain number of assets in bankruptcy that are held out, that are not counted towards the bankruptcy pot that's calculated to pay creditors with. Things like up to $125,000 of equity in one's home, that's exempt from bankruptcy. Up to a certain amount of value of tools of the trade, vehicle up to a certain value, those are exempt from bankruptcy, for example. A note here that if someone is filing bankruptcy for their business, if that individual who owns the business has personally guaranteed debts, they are likely going to follow with an individual bankruptcy because they personally guaranteed the debt of the business. This is the one that just looks at the different options. I won't go into too much detail, but Chapter 7 is what most folks think of for bankruptcy. This is put everything in a pot, see how much it's worth, pay the creditors, walk away. Clean slate. Chapter 13 is something that's really only available to individuals and small businesses. It's not available to corporations, but it's a catch-up plan. It says this is what the debt is right now, and the individual or the small business, they're going to get caught up in 3 to 5 years. There's a plan that's put into place, and they make those payments for 3 to 5 years. They're current by the end of that 3 to 5 years. Chapter 11 is similar. It's available for corporations, but it is specifically, okay, this business is failing. Let's not just get caught up. Let's reorganize it so that it's more successful. And that's a way to go in, rework the finances, maybe rework some of the loans. Creditors have to play in that one. They have to participate. They have to agree, but there's another 3 to 5 year plan that puts them in a better position at the end of it. And then Chapter 12 is reserved for family farms. This is a tool that a lot of farmers use when they find their land is undervalued or their business is failing, which happens a lot with farmers. They can go in and they can get some tax breaks. They can work with their creditors to rework the loans that they have. They can work with the Conservation Land Trust to try to get a little bit of money out of that. A lot of different options. It's a real good option for folks who are in debt and struggling with that if they have a family farm. That is bankruptcy in 2 slides.
That's amazing. So if for any of this stuff, is it good to have a lawyer or have some legal assistance when thinking about whether like torts or liabilities or debt, bankruptcy?
Here's where a lawyer is going to be the most useful before the problem happens. So if you want those 10 hours of free legal services, that will cover maybe initial formation of an entity if that's necessary. It will cover review of an operating agreement if someone has an LLC. It will usually cover just general advice about this kind of business. This is the potential risks that the lawyer sees. It could cover review of a few contracts to make sure that those are sound, that those protect the business. A lot can get done in those 10 hours. And yes, I absolutely recommend that folks who can access an attorney, whether through our program or some other means, do that as early as possible. Because of all the risks, because of the liability that flows to business owners, lawyers can see that and they can help figure out how to reduce that risk or how to make sure that the business continues even if something bad happens. Really, really important. It's possible to do it on your own. Lawyers are specifically trained to look at someone's circumstances and say, ooh, there's a risk. Let's put something in place so that doesn't hurt you. Ooh, there's another one and that could potentially get a lawsuit down the line. Let's put an agreement in place so that it has appropriate language that protects the business so that if there is a lawsuit, they're going to be okay. Let's put these assets over here in the separate LLC, which is easy to set up. Those assets are going to be protected if something goes wrong in operations, right? This is all the stuff that lawyers see. That's what they want to do to put pieces in place to protect you. And I'll just revisit the quote that's attributed to Ben Franklin that we don't really know who said it, which is an ounce of prevention is better than a pound of cure. That's basically why lawyers exist. Although they do exist to protect you if a lawsuit's filed. And that's another thing that they can help with. If something does go wrong, if you've been working with that lawyer, if you've already established a relationship, they know your business, they know the risks that you have, they know the contracts that you have, and they can better defend you if you do end up in a lawsuit.
Thank you so
And
much. Yeah. Oh,
honest to goodness, I just want to say, honest to goodness, this is a rising tides, lifts all boats situation. The better off all the small businesses are doing, the healthier y'all's businesses are, the better off we all do. So please take advantage of the 10 free hours or just see a lawyer.
yeah.
I won't go over this last slide, but this is really something I want folks to take a look at. What are the blind spots for most businesses? And we've gone over a lot of these. I think the only one that we haven't really gone over is permitting and regulatory compliance. We could do a totally separate.
That's going on the list.
Isn't it?
Y'all,
No, we
have
are
so many
actually, but that's when
topics
we're
that-
doing June 24th, right?
Yeah, we're doing regulatory compliance on June 24th. Next month is nonprofits. So if you have interest in that or somebody else has interest in that, please come to it. But upcoming topics, regulatory compliance, hiring your first employee, 250, how that impacts businesses, data privacy, intellectual property and AI, as well as hopefully bankruptcy and debt as well.
Yep.
So please follow us. This will be monthly except for the summer months, because July and August we are going to skip because it's nice outside and it's Vermont. So let's enjoy it. So hopefully we'll see you in another one. I will send out a wrap-up email to everyone in case like Nicole and Thomas have additional resources, as well as the slides. So if you have any questions, please feel free to reach out to me or contact the Vermont Small Business Law Center.
Great. And
Thank you
thanks for
so much, Nicole and Thomas. This has been
Yes.
wonderful. And